Hi, my name's Chris Needham. I'm a finance technical lead on the civil finance team. I've been in the role for 5 months now, but I've been with the agency for over 15 years. We'll begin by looking at file evidence, validating costs pre-submission. So starting with the relationship between the solicitor and cost person instructed to draft the bill. Generally, a lot of firms will use external costing firms or cost lawyers to draft the larger bills. When instructing them, providers will sometimes give global figures that they wish to include in their final bill. That may be for routine correspondence, the amount of enhancement they want to claim, and so on. Before sending the instructions for the bill to be drafted, providers should check that any figures that they've included in their instructions that they wish to be included in the final bill are actually correct and that there's evidence to support those costs. So that will include any global figures that they've taken from their costing system, any routine correspondence and phone call figures, any enhancement rates. Although the costing person should ensure that there's sufficient evidence on file to support these costs, we have seen instances where global totals have been included in the final bill, but there's just simply not been the evidence to support those figures. So it's important that you are making sure that there is that evidence before passing those instructions on to the costing person. So continuing with validating costs pre-submission, we're now going to look at the actions required when receiving your bill back from the cost draftsman or cost lawyer or costing person. So regardless of whether the bill has been drafted by the provider or an external cost person, it remains the responsibility of the provider to claim to submit that claim to the LAA. So when submitting the bill, CCMS requests that the provider confirms that the claim is actually correct. You should only confirm that it's accurate once you are happy with the actual bill. So you should be carrying out checks once receiving the drafted bill back to make sure that it is correct. It's important that you have pre-submission checks in place, as they'll allow you to pick up on any potential errors made by the costing person. If, for instance, they've included global figures that are inaccurate, or if they've included work that you simply don't have file evidence for, you'll be able to pick up on that. And that will help to avoid any delays in payment or help to reduce any additional resources spent by you or the LAA correcting bills post-submission. And it will also reduce the impact on your key performance indicators. Moving on to providing file evidence. As you'll be aware, we don't often ask for the full file of papers at the assessment stage. However, under the contract, we can request your file or any supporting evidence anytime during the life of the certificate and up to 6 years after it's been closed. You may therefore see requests for your file on any case. It's worth remembering that by submitting your claim, you are confirming that all evidence is available to validate your claim. So you should try and provide the requested information or evidence as soon as possible, and that will help to avoid any delays in payment or the possible rejection of your claim. Going to move on to post-payment audits now. So LAA will also carry out post-payment audits and must account to the National Audit Office. This forms part of our responsibility to them. We need to be able to demonstrate effective stewardship of the public fund. So this doesn't mean disallowing all of your costs and being strict with the fund, but it does mean that we can only pay for costs that have actually and reasonably been incurred are within the scope of public funding and are supported by file evidence as per the contract. This is why it's important that we can actually validate the work claimed. So any request for evidence you should be taking very seriously. If we can't validate the work, then there's a good chance that those costs may well be recouped on a post-payment audit. Again, when your claim is being selected for auditing, you should try and provide the file and any other requested information as soon as possible. This will prevent further requests for the information. It will again reduce the additional time or resource spent by yourselves or by LAA. And it will also prevent potential recoupment of your costs. Also allows LAA to spend more time paying your claims rather than having to divert resources to carry out stewardship or assurance-based tasks when your claim has already been paid. It's also worth noting that because the file isn't always required on assessment, there may be times where costs have been paid by the LAA on assessment, but only once your file is provided on an audit, it's identified that there's issues with the claim. For instance, file evidence may be missing. If the claim isn't correct, then and LAA has paid it and needs to carry out recoupment post-payment, then obviously that doesn't look great for the LAA's reputation, and it doesn't look great for providers' reputation. So it is important that we're all getting it right first time. Moving on to routine correspondence and telephone calls. So we've seen cases where costs have been paid on assessment, but where the file when it's been audited, there's been long periods of time not accounted for, and that includes numerous amounts of routine items of work, such as the routine telephone calls and correspondence. There's a few things that should be happening, and many of you will already be doing this as part of your standard process. First one is to please ensure when drafting the bill that all letters, emails and phone calls are only claimed where there is the appropriate evidence in support of these available on file. So for instance, it could be a copy of the letter or email chain, or it could be a copy of the attendance note supporting a phone call. Second thing that should be happening is please make sure where evidence is requested that you provide all of the relevant files, including any separate correspondence files. There have been instances on audit where the full file has been requested, the audit's gone ahead, and then it's turned out the period of time included in a separate file is not being accounted for. It's been provided at a later date, but then that's added additional resource spent and delays spent by both the provider and the LAA. So it's best practice to avoid that and to provide all of your files when they are requested. The third thing to remember is all correspondence must be progressive where being claimed. We can't pay for things like a generic thank you or an automated email response. Finally, long email chains that are conversational in nature shouldn't be claimed as individual items. So that's where the email chain may include niceties. It may be back and forth, like with question raised, question answered. Not everything being raised in a single email and then a single response. It's mostly where there's a bit back and forth. So although that should be claimed as a timed attendance, please make sure you're not also claiming an additional routine item in respect of any timed attendance we're claiming on a time basis. So now we're going to look at the kinds of evidence needed. So whether dealing with controlled work or certificate work, file evidence and the way you organize your file remain the same regardless of whether it's controlled or certificated. So based on the type of costs you're claiming, CCMS will request the documents needed to validate a claim for certificate work. You may, however, see some instances where additional information is required on assessment. It may be that the caseworker requires this additional information in order to make a fair assessment of your claim. So caseworkers can request this even if it's not included in the initial document request. Where the file or part of the file is needed, further document requests will be sent on CCMS. However, we're not able to hold the bill indefinitely. So if you delay in providing the requested evidence, it may lead to your claim being rejected. So please bear that in mind. We've set out a non-exhaustive list in the slides of the type of documentation required. So generally, a case narrative will be required in support of all claims. This should give a brief overview of the case, including how it concluded. Basically, it's an opportunity to explain any unusual costs as well. For instance, it may be that you're claiming an entire expert fee that would normally be expected to be apportioned between the parties' certificates. You can use the narrative to explain why it hasn't been apportioned, that kind of thing. The more information you give us and the clearer you are in the first instance means the less likely we are to need to request additional information. We also require justification for enhancement, especially where it's a discretional enhancement. So you should try and support your claim and explain explicitly how your claim for enhancement meets the two-stage criteria set out in section 12 of the cost assessment guidance. So moving on to the type of evidence we need for profit costs. Generally, if it's a fixed fee matter and it's under the finance aspect, if you're claiming the settlement fee, we will require a copy of the order or agreement with the claim so we can see what has been agreed in that under the finance aspect and how the case settled. In certificated matters claimed on an hourly rates basis, evidence is required for each hourly rate item over 3 hours. That differs to escape cases where the evidence needed is for items over 1 hour and not 3 hours. So there's a slight difference there. Also, regarding escape cases, the team are currently carrying out checks on the full file of papers for cases that are up to £100 over the escape threshold. So the file will be required and they will request the file in those cases. Please also remember that you'll also need to supply the means evidence for escape cases as well. Generally, where the LAA required a file of papers, then they may request it for a prepayment assurance checks, as well as any post-payment assurance checks. So where it is needed, please don't send your full file of papers on every case. We will request it on those cases that it is required. Going back to fixed fee matters, where they've escaped the fixed fee, and if you've opted to include both firms' costs where there's been a transfer of provider, if you've included both firms' costs in a single claim, then it must be clear which costs relate to each firm so that we can confirm that both firms' costs escape the fixed fee. that about covers it for profit costs. Going to move on to the evidence required for solicitor FAS. So we've moved away from the advocate's attendance form, as you'll be aware of. We generally require a copy of the court order for FAS hearings now, but we will still accept the advocate's attendance form for historical cases where it's been sealed. For most cases, where the order should set out the following, so we can confirm the correct FAS fees being claimed. So the order should say the type of judge, it should confirm the hearing date, the type of proceedings, the type of hearing, the size of the advocate's bundle, the time of any pre-hearing discussions, start and end times of the hearing, including any time granted to agree the order. It's useful if you include the total length of the hearing and details of any bolt-ons and who may claim them. And also, if there's been any advocates meetings prior to the hearing, then you may also want to include that as well. Generally, we expect there to be 2 advocates meetings under the public law outline. Do require court orders directing the third and any subsequent advocates meetings. It's worth noting that that's the order in which we pay them, so it's not necessarily the order in which they took place. So if counsel have already claimed 2 advocates meetings, we would then require a court order in support of the third, even if that meeting took place before the 2 claimed by counsel. Best practice, I would say, would be to upload your order directing the advocates meeting. In that way, you just won't get caught out if counsel have already claimed to. For historical cases where you're relying on the advocate's attendance form, then please remember a copy of the consent order or agreement is still required where you're claiming the early settlement fee under the finance aspect. And also, you'd need to submit a copy of the final order where you're claiming an issues resolution hearing, so we can see that the case concluded at that hearing. Moving on to disbursements, you'd all be very familiar with the evidence requirements for disbursements. They haven't changed much since 2011, so this shouldn't come as a surprise to anyone. We require disbursement vouchers in support of all disbursements of £20 and over, and that's inclusive of VAT. For experts, we'll generally need an invoice with a breakdown of work included, and that should include details of any locations travelled to and from. If due to the age of the case you're unable to provide that level of evidence, then you should include some explanation as to why, and if there's no invoice, you should include a copy of the report, a copy of your office ledger, and also it's useful if you also provide a copy of the order directing the expert and the instructions to the expert as well, and that will just help us to make a fair assessment of your claim. Where prior authority hasn't been granted, you should upload a copy of the court order for certain expert types, and so that will include drug and alcohol testing, risk assessment experts, and also in support transcription fees for transcription of judgments. Moving on to tax bill / voluntary assessed bill evidence requirements. For tax bills, that's those bills that have actually been assessed by the court, we will require the sealed EX80 and the bill of costs. For voluntary assessed bills, those are those bills that would formerly have been sent to the courts for assessment, but you've instead opted to send them to the LAA for voluntary assessment instead. You can choose to submit those on CCMS as either a line-by-line claim or on a summary basis. If you've drafted the bill on a summary basis, then a copy of the bill of costs or a claim one should be uploaded with your claim. Alternatively, if you've used bulk upload and your software creates a clear breakdown of those costs, then we may accept that as well. For hourly rate claims submitted on line-by-line basis, then you should still provide details of work and the usual requirements. Regardless of whether you claimed on a summary basis or line-by-line basis, FAS must always be submitted on a line-by-line basis. Usual FAS and disbursement evidence also applies for those cases. Now going to look at some hints and tips on submitting evidence. The way in which supporting evidence is provided can cause significant delay when we're attempting to validate your costs. There have been occasions where evidence has been missed on assessment, and that's been largely due to the way the evidence was uploaded onto CCMS or the secure file exchange platform that LAA use called Galaxy. So to help prevent that happening, there are ways you can ensure that the information you're providing and the evidence you're uploading is easily accessible and helps us so that we don't miss anything that you've provided. So the following are hints and tips on helping us to pay your costs. So the first one, please only provide the evidence requested. If you're giving us pages and pages of documents that aren't required, then it makes it that much easier to miss what is relevant and needed. Secondly, file evidence should be in chronological order. That's fairly standard practice. However, we do see cases where either supporting evidence or files are just submitted in a random order, which is not very helpful. When uploading documents onto CCMS or Galaxy, please make sure that you're labeling any files clearly and accurately. Just listing them as documents or having an inaccurate label just isn't very helpful. When you are uploading documents, it's helpful if you group them into appropriate groups. For instance, you should put disbursement vouchers together, court orders together, so that there's some reason, some rhyme and reason and logic to the way the documents are uploaded. Obviously, that becomes less important where there's only a couple of documents to be uploaded, but where you're uploading loads, then it does help to make sure they're grouped sensibly. Fifth reason, please avoid uploading duplicate documents. Obviously, if we're having to wade through duplicate documents again, then that can make it easy for us to miss the documents that we do need. Hint and tip is highlighting relevant directions in court orders. Caseworkers find this particularly helpful, and it just means that we're less likely to miss any relevant directions within your court orders. Seventh hint, documents should be submitted the correct way and not upside down. Sounds fairly obvious, but we do sometimes see documents upside down, which is obviously takes more time to go through. And then the final hint, again, it's very obvious, but documents must be legible. If the handwriting is extremely messy, or the copy is too faded to be read, then we can't read it. And so you're running the risk of us either returning and asking for a legible copy or disallowing the cost. There is further guidance on the model file submission article available on the gov.uk website, and there's a link to that included in the slides. Now going to look at enhancement for panel membership. In family matters, you'll be aware that there's a 15% guaranteed minimum enhancement, and that's available on hourly rates where the work has been undertaken by a panel member. In order to claim this enhancement, the fee earner must have been a member of either the Resolution Accredited Specialist Panel, the Law Society Family Law Panel Advanced, or the Law Society's Children Panel whilst carrying out the work. Generally, if work is claimed on a line-by-line basis on CCMS, then you'll be able to confirm when drafting the bill that the work was undertaken by the fee earner. And so that will make it nice and easy for LAA to see where the who undertook the work the enhancement's been claimed on. If you're submitting a bill on a summary basis, you'll need to confirm in the supporting documents, whether that's a bill of costs or a claim one, who the panel member is, and it should also be clear from the document which work the 15% enhancement has been claimed on. We have seen cases where the 15% enhancement for panel membership has been wrongly claimed on work. So a few things to do. Please check to make sure that your membership hasn't expired. There have been incidents where the fee earners claimed the enhancement without realising that their membership had in fact expired before they carried out the work. The enhancement can only be claimed where the work has actually been undertaken by the panel member. So make sure that they're a current panel member. It's also worth noting that it can't be claimed on work carried out by a non-panel member, even if they've been supervised by a panel member. So if a non-panel member has undertaken the work and the panel member has been supervising, the enhancement wouldn't be claimable in that situation either. Regarding supervision, generally it's considered to be an overhead of the provider, so we wouldn't expect to see these costs claimed anyway. It's worth noting we do carry out online checks on assessment to see if the fee earner is a panel member, but generally that will only confirm whether they're a current member. We can't see via those checks whether they used to be a member or not. So we may need to query this on assessment at times. If you're claiming enhancement for a fee earner that's no longer a panel member, you may wish to upload a copy of the panel membership certificate so that we can see the period of membership, and then that will just avoid us having to query it, and it will avoid any delays in payment. It's also worth noting that we do search for panel membership evidence on file on any post-payment audit as well. We're now going to move on to family advocacy scheme and how to avoid delays due to issues with FAS. So generally, the same rules under the family advocacy scheme apply to solicitors and counsel. Obviously, there's some exceptions. For instance, counsel can claim an opinion fee, or they can claim a conference fee, which aren't available to solicitors. Also, counsel may claim payment of their FAS fee at any point after undertaking the work during the life of the case, whereas solicitors will generally need to either wait for that aspect to have concluded, or will need to have waited for the certificate to have been transferred to a new certificate, whichever came first. Slight difference as well in a way. Cancellation fees are claimed with counsel being entitled to either hearing unit 1 for interim hearings, or half the final hearing fee, where they show that 30 minutes of preparation work has been undertaken, whilst solicitors would just generally include those costs for preparation within the representation fee where the hearing has been cancelled. But on the whole, aside from those, the FAS is pretty much the same for both solicitors and counsel. Generally, bills are assessed on a risk-based assessment. The information available at the time of considering counsel's claim, however, may be somewhat limited. So it does mean that, unfortunately, sometimes we'll get to the solicitor final bill stage and new information will have come to light. That means that we then need to query the payment made to counsel as well. Unfortunately, that's unavoidable, just given the nature that we do pay some counsel we pay counsel fees earlier than the final bill. To help avoid any delays in paying your claim now and any issues with counsel's bill, there are a few things you can put in place to help avoid that and to avoid your claim from being returned. So you should include a copy of the certificate with your instructions to counsel. This will allow them to see the scope of the certificate so they can see exactly what they're covered for. This is actually a requirement under the contract, so you should already be doing this, and I appreciate many of you already are. They can also see on CCMS the scope, but the certificate just crystallizes exactly what work they're covered for. Second thing you can do is make sure in your instructions that you're clear what type of hearing they've been listed, specifically for remuneration purposes. So, for instance, if you've instructed counsel to attend a directions hearing, you could include in your instructions that they can claim that as a final hearing, regardless of whether the case concluded at that hearing or not. And just that kind of guidance will help when it comes to the final bill stage. You can also assign counsel to a case on CCMS without allocating costs to counsel. So you can assign them. I appreciate some counsel won't undertake work until costs have actually been allocated to counsel. So please do make sure you're checking whatever quote they've given you before allocating them costs. And then make sure you do check counsel's fee note once costs have actually been claimed on CCMS as well, or prior to costs being claimed on CCMS. But if you don't have a chance prior to them being claimed on CCMS, make sure you've checked after they've been claimed on CCMS before you submit your final bill, so that you can confirm the counsel have actually claimed their fee correctly, and that there won't be an issue come the final bill stage. Before submitting your bill, You should check your file to make sure that all counsel that were instructed in the case have been allocated costs on CCMS. And then you should also check CCMS to confirm counsel have been paid. The case costs details screen on CCMS will show the amount allocated to counsel, and it will show the amount that they've actually been paid. So the amount allocated and the amount paid should actually match before you submit your claim. Otherwise, you run the risk of your claim being rejected. And that concludes the webinar. Thank you for taking the time to watch this.